House of Howard L. Upchurch. We represent George Olin Kerley, the appellant husband in this matter. And I would like to reserve 5 minutes for rebuttal. Thank you.
All right, that'll be fine.
This is an appeal on a divorce action. It was a long-term marriage, a marriage of approximately 56 years. And of course, there's no minor children at issue today or then. There are two issues before the court today. One is the equitable division of the marital property, and the other is the award of transitional alimony to the wife. Specifically, the first issue is whether the trial court erred in the distribution of the parties' property by not allocating the proper weight to the factors set forth in TCA 35-4-121C, and by failing to make findings of fact on the record. I think most importantly that it is that the trial court did not address the factors at all in the final decree of divorce in regards to the division of the marital property. The second issue is whether the trial court erred in granting temporary alimony based on the financial need of the appellee. And again, I think most importantly, the trial court didn't address the financial need of the appellee wife at all in the final decree of divorce. When addressing the division of the marital property, the trial court's overall division of property is reviewed for an abuse of discretion, and I think that's very important here in this case because under the standard, the trial court is empowered to do what is reasonable under the circumstances and has broad discretion in the equitable division of the marital estate. The division of assets is not a mechanical process, as noted. The trial courts are afforded considerable discretion. Accordingly, a trial court's discretionary decision will be upheld as long as it's not clearly unreasonable, and reasonable minds can disagree about its correctness. However, discretionary decisions must take the applicable law and the relevant facts into account. And this is where we have our problem, is that the trial court did not do this.
Excuse me for interrupting, counsel. If it is determined that there are insufficient findings of fact and conclusions of law, is your client requesting that this case be remanded to the trial court for those findings to be made?
Yes, Your Honor, that's my understanding.
Thank you.
Welcome.
What was the division of the property, just roughly? Did your client, let me ask you this way, was he awarded more of the marital property?
It's my understanding from looking at the division of property, he was awarded slightly more.
Mm-hmm. And
However,
he understands that if it goes back on remand for the trial court to make the findings of fact and conclusions of law, it could be a completely different determination.
I agree, Your Honor, it's a roll of the dice. I agree.
Okay.
Excuse me for interrupting again. Have you made a calculation in terms of percentages between the parties in terms of the equitable division of marital property?
I believe, just off the top of my head, that Mr. Kerley, the husband, received 53% of the marital property, and I could be wrong, I'm going off the top of my head, and that Ms. Kerley, the wife, received 47%.
Thank you.
You're welcome. Thus, the abuse of discretion occurs when the trial court causes an injustice by applying an incorrect legal standard and reaches an illogical result. Here, our argument is that there wasn't a legal standard provided at all in coming up with the division of the marital estate, and as far as the illogical result was that that the property and its use was incongruent with actually how the property was distributed. the Litton house, for example, which was the very first house that the Kerleys purchased and lived in, as the marriage progressed, that house was rented. But also, there was a shop there on the property that Mr. Kerley used in his construction business. There was a pole barn constructed where Mr. Kerley used to store hay for his cattle operation. And also he used that particular property and the structures on the property to doctor and work his cattle. Of course, I think that it's important to point out that some of that cattle was sold, but historically, what the family had used that property for was they had a small herd of cattle. Then also there was, and I think also important to note, as reflected in the record, is that Mr. Kerley remodeled that house 3 separate times over the course of their ownership of it, and each time he did that on his own and through his construction business. And so he contributed a lot to that specific property. And then of course there's the house that they lived in prior to separation that he built and designed, and that he believes that he contributed more to. Regardless, I think more so the issue before the court today is that there's no findings of fact regarding the trial court's basis for the distribution of the marital property, as was outlined in the final decree entered in August of 2020. And that it did not at all discuss the TCA code, that those specific 12 factors when deciding on how to distribute those marital assets shall be considered. And of course, that language is not discretionary, that's mandatory under the statute. And I think more so too that in those 12 factors and other factors that the trial court would have felt were important, that those factors were also supposed to be weighed, and there's no evidence in the final decree that those factors were ever even considered. So, which gives, I think, the court a very difficult task in trying to evaluate or give discretion or determine what legal standard the court used in making the distribution of the marital assets. And in regards to alimony, you have the same issue. It's the same issue. It's still an abuse of discretion standard, and not absent, but I mean, if the court doesn't apply the applicable legal standard, then it's hard for a determination to be made as far as whether the award of alimony was indeed proper. Again, also you all have the same issue as far as there's a Tennessee statute that is on point on that, where you've got to evaluate and analyze those factors, those 12 factors. And again, that language is not discretionary; it is mandatory, and it was not done in that final decree. I think what we're asking the court to do here today is to remand this case back to the trial court for appropriate findings of fact to consider those 12 factors in regards to the division of the marital
property, and also in determining whether that award of transitional alimony was proper, and those 12 factors also to be considered and weighted and analyzed. And so, unless you have further questions to me, I will be happy.
I hear none. You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Good afternoon. My name is Jennifer Mitchell, and I'm with the Sequatchie County Bar. I'm here representing the appellee, Linda Kerley. This was a 58-year marriage. It was a difficult situation as these parties married when Miss Linda Kerley was 17 and Mr. Kerley was 19. The marriage fell apart simply because he found someone else, a younger lady that had some drug issues that he sired a child with, and moved from the marital residence after an order of protection across the field to the brick home with this lady and the child. The trial court, after hearing the proof for 2 days, awarded Mr. Kerley, even though Ms. Kerley was granted the divorce, gave him 53% of the assets and gave her 47% of the assets. The other thing that I think is very important in this case is that the trial court did find about the length of the marriage. He found the date of the marriage as well as the date of separation, and ultimately they were divorced by decree in 2020. But I think it's important to note that when the court finds, and I agree that he made very few findings, but he did make findings. And he found that at the time they accumulated all of the assets they had and had grown this marital estate to approximately $2 million. He also found that they both worked hard to accumulate all of these assets together. And so he simply, in his final decree, points out that they came from zero and went to $2 million, giving the husband 53% and the wife 47%. But also, if you look at the income and expense statements of the parties, Mr. Kerley, at the time of trial, had 84% of the marital income coming into his household, while Ms. Kerley had only 16%. I think it's important also, Your Honor, that in the appellant's brief, they attack the division of marital property. And in doing so, he's simply asking for the marital home versus the brick home, which he had moved into the brick home with his 2-year-old child, and the appraiser found that it was much less unkept and was cluttered and needed some maintenance, whereas the brick home was much nicer. And they were valued within $25,000 of each other. And then but in doing them, and then he's asking for this Litton home. The problem, if you look at Exhibit 13, is the Litton home is essentially joining the brick home. And so they're right beside each other. All of these properties are contiguous.
Excuse me for interrupting,
I'm
counsel. As you have articulated, the trial court made some findings
Yes.
of fact. But the trial court did not make findings with regard to a number of factors. Does that create problems for a reviewing court in making a determination how the trial court arrived at its basis in the nature of the equitable division of marital property, the amount of that division?
It could. In the Diffie case, which is cited by counsel in her brief, it's an unreported decision, and it cites the Lovelace versus Copley case. And it talks about that it doesn't have to look at every factor. It says, while there's no bright line test by which to assess the sufficiency of the trial court's factual findings, the general rule is the finding of fact must include as much of the subsidiary facts as necessary to disclose to the reviewing court the steps by which the trial court reached the ultimate conclusion. Now, I don't think that answers your question, but the second part of that Diffie decision goes on to say, if the trial court fails to explain the factual basis for its decision, then the appellate court may conduct a de novo review of the record where the preponderance of the evidence lies, or remand the case for instructions to make requisite findings of fact and conclusions of law. The second part, where they're coming in today and saying it's okay to have a reprimand, and the concern of my client is this case was heard in 2020, back when they were 75 and 77. We're 4 years down the road. The trial judge has retired. So we're essentially going to have, if this case gets remanded, we're starting from scratch with a new judge that's been on the bench since 2022. And my client has to, as well as Mr. Kerley, has to have the expense of a trial. And Your Honor can see that she has very limited income, and the expense of this trial was very difficult. The trial court also found essentially every one of husband's values. We both had appraisals, we both had experts on personal property, and when you look at the Table 7 and the final decree of divorce, the court adopted almost every one of husband's valuations except the valuation of the brick home that he's living in, and both parties valued it more, and the trial court reduced the value even though he got a large brick home with approximately 20 to 30 acres. So I think there's a remedy for this court, and I think counsel and I both have pointed out in our briefs that there are sufficient facts in the record to apply what has already been before the court to establish, even if the trial court failed to properly consider 34-4-121 and I'm sorry, 36-4-121 and the alimony factors. Both of us have established in our briefs the fact that there are findings in this record to support the trial court's decision. And simply just remanding the case doesn't have judicial economy. My client obviously did not get a fair shake out of the division. Counsel cites the Dillinger case in her brief to the proposition that this should have been an equal division, and it should have been an equal division. She worked hard. She worked at a factory for 30 years and provided health insurance so that he could be self-employed. They had a really nice life together, which was testified at trial, up until he decided to find someone else, someone younger that needed him. And counsel in her brief talks about three different reasons, the three factors that she relies on. One, the length of the marriage. I think there is a finding of the length of the marriage. The court found that they were married on September 8th of 62 and separated in July of 2018. So I think counsel is incorrect. The second thing she talks about as to the division of marital property and why the court failed to make a finding of fact is the wife's the contribution of the parties or the dissipation. The court found that both parties contributed to the accumulation of these assets. And so I think that finding is in the record. And if you look, both parties contributed. That's in paragraph 2 of the final decree on page 1, and both parties worked to accumulate assets. That's paragraph 4 on page 2. The appellant spends quite a bit of time talking about the dissipation of the marriage and trying to utilize the dissipation. The court did not make a finding of dissipation, and you can see that in his final decree on the $100,000 that the wife took from the joint account. The wife itemized on Exhibit 29 every expenditure that she had made. Husband wants to come in this brief and say that she dissipated assets. But if you look at that, and the trial court cut us off and did not want us to go through every one of those, she was paying the phone bill, the electric bill, the property taxes on all of this property. She was paying the insurances. He took the lawnmower, and she had to go buy a lawnmower to mow her grass. In fact, the husband said he did not contest the use of this money. He was upset she took it, but that he was not upset about the way she utilized the money. So I think it's misplaced for Ms. Kerley to have to come in and defend the argument of dissipation when the husband is the one that spent $31,000 on his girlfriend's teeth, bought her a $14,000 automobile when she didn't have a driver's license for DUI, paid the car insurance for this car out of the marital account, provided her with a home, and also provided her with bail money. Finally, the appellant talks about that the court should have considered a factor that they have created under number 12 as an agriculture use. The problem with the agriculture use that they have come up and raised in this is that essentially that was never before the court as far as this property being used for agriculture. They did, both parties said they did do farming. However, the court ordered the cattle sold. The court, both parties testified that the majority of the farming and the farm equipment was at another piece of property owned by some family members at JLK Road or Lane. And the husband ended up with the brick home that had the majority of the land. In fact, in the motion to alter amend, the wife was asking for the portion of river bottom behind the marital residence so that husband couldn't get behind her house, and that was denied. The wife also asked for a portion, more of an equitable portion of his IRA to offset the difference in the 53-47 split, and that was denied. So I believe the factors one and that they talk about, one and two, the length and the contribution were talked about by the court. I don't think it's necessary to have a functional use argument. Now, the other thing is the alimony. With regard to the alimony, once again, I would cite the Diffie case to the no bright line test regarding the factors. The court makes a statement that he does find that it's a long marriage and that the alimony should be taken into account. Furthermore, in the record is the income and expense statement of the wife, which clearly shows she has a need.
Excuse me for interrupting
Yes.
again. As I understand, the trial court did not make findings with regard to the form of alimony, the nature of the alimony. It ordered transitional alimony, but there were no underlying reasons or bases which were identified as to how the trial court analyzed the factual circumstances in this case and arrived at the nature of the alimony that was granted. Is that correct?
It is, and I don't, and from a transitional, right, and I mean, we could certainly speculate. The record is what it is, and it does establish that she's retired, she's 75, she's not going to make any more money. The assets are what they are. One thing that counsel argues is about this $131,000, and I believe their table 7 is incorrect because there was a Ponderosa property, and what the court did is they gave $131,000 to the husband and $131,000 to the wife, and said that husband was to continue paying the debt. In their table 7, they put the entire $131,000 on the wife, but failed to allocate $131,000 to the husband. So as a result of their table, it actually puts excessive amount. If you put the $131,000 on husband's side, it actually brings him up to $1,066,000 and wife only to $935,000, because it's clear in the final decree of divorce they owned a half interest in the Ponderosa with another couple. But that half interest, he then divided into a fourth. The wife owned 131 and the husband owned 131. There's also in their brief some allegations that that is to be sold, and that property, that she would have a windfall from that $131,000 cash. The problem with that is there's no proof that that has been sold, and husband would get the same amount of equity when it is sold. So to offset and say she's getting a windfall, she's not getting a windfall because he still is getting substantially more as far as assets are concerned. The trial court in the alimony, if you looked at the asset and liability statement, specifically husband's Exhibit 40, or the trial Exhibit 40, husband has an additional $2,049. I think it's also important for the court to recognize that in his income and expense statement, $700 is what he's paying for this child he has now had. He's paying he's listed $550 as insurances that the wife is showing she's had to pay out of marital funds on Exhibit 29. He's put $407 as property taxes that the wife has had to pay out of these marital funds because he's not paying, and he's paid his attorney $500 a month to try and appeal this case, and so that adds an additional $2,100. The court found that Ms. Kerley was not able to pay her attorney and awarded my attorney fees. Your Honors, this is a case where she got less than 50%. She worked hard. She raised their children. They've made a life together. He chose that life, and now she's left with 25% of the marital income. She's left with less than 50% of the assets, but yet she is not seeking remand. She's seeking finality, and she's just asking for finality. She is asking for attorney fees. There's substantial assets that Mr. Kerley can pay for that, and he should have to do that.
Counsel, let me take, you said the $131,000 that one was not allocated to husband?
It is in the final decree, but in their table 7, I believe they put it solely on the wife and don't allocate husband with the 131. They've each got 131,000.
Okay, maybe I'm looking at it wrong, but it looks like they do on page 5 of the 7.
Of husbands?
5.
I'm sorry, Your Honor. Okay, so they're putting the total value as 131,000, and it should be 262. So husband got 100 and,
And wife is also allocated 131,000.
okay, maybe I'm incorrect. I think the total value is 262,000. I think my point is that number should be 262,000, not 100. The total value is 262. See, I think the way I understood table 7 was the total value of the asset. And see, I think that amount should be 262,000. 375 was wife's value, 262,000, and they say wife got the entire asset. But if you look at my table 7, I believe I put it as 262,000, Your Honor. Do you see what I'm saying there?
Not really. It looks, because the table I'm looking at has wife at 131,000, says 1/2 interest, and husband 131,000, 1/2 interest with husband shall service debt pending sale.
Okay, if you look at my table 7, what husband had put at 131,000 for his column, but the actual they own a half value, so they were each awarded a fourth. So the total marital value is 262,000.
But wife got how much?
131, and husband got 131. But
Well, that's what's listed on the court's table, isn't it?
No, Your Honor, because this is the actual trial value, and then at the bottom, they don't add, they don't list, it should be 206, the total marital value is what goes in that table.
I understand that, but
Should be 206.
I understand that
Okay.
the total marital value of that, but if you give 1/2 to wife, that's 131,000. If you give 1/2 to husband, that's 131,000.
Yes, and if you look at the last column of their, it says party to whom it's awarded to, and it just says wife on their table, but it wasn't awarded to wife. It was actually, each one was awarded 131. So I think if you total those up at the very bottom, when you look at their very bottom on page,
I don't understand why it would go up. I understand the total value is 262, but wife got 1/2 of it.
but that's not what they show on their table. If you look out to the right, they're not showing that on their table. They're saying that wife got all of that.
On page, okay, I'm looking at the trial court's table.
At the trial court's table,
Yes, the distribution of assets.
yes, wife got 131 and husband got 131 on the
Yes.
trial courts. If you look at their table
their
7,
table, okay,
it's different.
I understand now.
Yes, okay.
All right.
Thank you so much.
Okay. Hear from the appellant, rebuttal.
I do just want to note, and that.
Counsel, if you don't mind, step over here for the microphone because
I
it
did
is
just want to
being.
note just that Ms. Kerley was awarded her attorney's fees, and I believe approximately $25,000. So, but other than that, I rest.
Okay. Our thanks to both of you. We appreciate your arguments today and your briefs on it. Counsel, wait 1 second. Okay, adjourn court, please, but just adjourn court.
All rise. This court stands adjourned until 9:30 tomorrow morning.